Seated. Good morning. This is cause number 220123, Camen versus Glacier Eye Clinic. It's the time set for an oral argument. Are counsel ready to proceed? I guess it's Ms. Sheehy going first here.
May it please the court. I'm Martha Sheehy, and with Craig Dowie, I represent the plaintiff below, Brett Camen, appellant here. I know you've all read the briefs detailing the story of Brett's tragedy. You know the ending. Brett is permanently blind at the age of 21. From the time that Brett filed this suit in April of 2019, he focused on a single legal theory. Brett pursued this medical malpractice case on a theory well recognized under Montana law. Brett asserted that Dr. Wheeler and Dr. Stein delayed treatment of his fulminant IIH, which may result in blindness, and that delay in the treatment, in the surgical intervention, reduced his chance for a more successful outcome. On the eve of jury deliberations, the trial court refused to instruct the jury as to Brett's theory of the case, with respect to both duty and causation. The jury was never told that Montana law specifically allows a cause of action for loss of chance of recovery. The jury was never told that all negligence is based on the reasonableness of the defendant's conduct. Brett never had a fair chance, given that his theory of the case was never presented to the jury by the trial judge. Counsel for GEC made a really good jury argument below. His argument was built around the theme that instructions are an operator's manual that tell the jury how to apply the evidence and how to get to a verdict. He argued that the jurors must follow the instructions, the operator's manual. This analogy amply demonstrates why the failure to instruct on the theory of the case was prejudicial error that deprived Brett Camen of a fair trial. Because the operator's manual that was presented to the jury was missing essential chapters, namely the theory of Brett's case on duty and causation. Before addressing the two individual instructions, it's important to note that the failure to instruct on theory of the case is reversible error. As this court stated in Chambers, and I mean the case, not the place, in Chambers, and in the other cases cited in the brief, the failure of a court to instruct on a party's theory of the case is not only prejudicial, it constitutes reversible error. Defendants have never responded to that, to the theory of the case being reversible error. Absent instruction on the theory of the case, Brett did not receive a fair trial, and reversible error has occurred. I'd like to first address plaintiff's offered instruction number 9. This is the proportionate duty instruction. It's found at Appendix 133. That instruction, as offered, stated, the care required of a defendant in a negligence claim is always reasonable care. This standard never varies, but the care which it is reasonable to require of the defendant varies with the danger involved in his acts and is proportionate to it. The greater the danger, the greater the care that must be exercised. The trial court rejected this instruction for a legal reason, and that legal reason has to be reviewed by this court de novo. I've given you a handout that has the rulings, all of which were in the transcript. I've highlighted the rulings for your perusal. At the Appendix 77, second page of your handout, the trial court ruled, it is this court's concern that this instruction will encourage the jury to exercise what in its discretion or belief is the appropriate standard or how to apply it, how vigorously to apply the standard of care given by the experts when it really must be defined, if at all, by the experts. This is an incorrect conclusion of law. The experts provide evidence as to what the standard of care is, and the jury is to determine how to apply that standard. How to apply it is on the reasonable scale that is always present in negligence, and the jury was not instructed as to that.
Ms. Sheehy, I have a question about that. The medical malpractice statute on expert witness testimony and qualifications specifically provides that the standard of care is specific to the disease or injury for which the plaintiff was being treated, and that the expert has to be thoroughly familiar with the standards as they relate to that act or omission. Doesn't that subsume the duty varying with the degrees of what's going on, danger or the specifics of the situation?
No, it does not. The duty is still, as stated by this court in Streever, applying the restatement, the proportionate duty. There is no case law in Montana addressing this, but the trial courts have been giving this instruction in medical malpractice cases. And the reason it's not subsumed is that, again, the experts testify and the jury uses that information, that evidence, to determine the standard of care. But whether that standard of care is breached must be looked at on the scale of reasonableness. Otherwise, this isn't a negligence claim. It's left entirely to conflicting testimony of experts, and the jury had no information how to place this in the context of a negligence claim, which requires a reasonableness analysis. The instruction given in this case, or not given, the proffered instruction, may not have been the best construction for this case, but the trial court was under an obligation, as this court stated in Peterson, to tailor an instruction to the theory of the case. This is an obligation that exists for the trial court even if the parties fail to offer a proper instruction. So once the district court decided not to give this instruction, it had an obligation to tailor an instruction that included reasonableness. We've offered an instruction from the court in DC, the Panu case. The Panu court gave a great analysis of the proportionate duty instruction as it applies in medical malpractice cases. Referring to the proportionate duty, the court in Panu stated that these fundamental principles of negligence law also are applicable in a professional negligence case. Furthermore, the context of a medical negligence action is critical to a determination of what constitutes reasonable care under the circumstances. So the court could have tailored an instruction with the proportionate duty that took into consideration the other instructions regarding how the expert testimony must be presented. But third, the trial court erred here in that it never offered any instruction whatsoever about reasonableness. Because it threw out this instruction that we offered, there was not a single instruction that advised the jury that negligence exists on a scale of reasonableness. The first line of our offered instruction, the care required of a defendant in a negligence claim is always reasonable care. That's a correct statement of the law. And to send a negligence case to the jury without an instruction on reasonableness is to preclude any discussion of foreseeability. This court in Busta held that you shouldn't instruct on the meaning of foreseeability, that you handle foreseeability by MPI 200.1, which defines negligence as the failure to use reasonable care. Jury never got that instruction because the trial court eliminated Plaintiff's 9 in its entirety. So even if this court were to determine, which I encourage it not to, but even if you were to determine that proportionate duty doesn't apply in medical malpractice, Brett Camen was at least entitled to an instruction regarding the reasonable care duty. When the trial judge held that medical malpractice is a special subspecies of negligence, may be true. There are specific instructions that have to be given, but there is no subspecies of negligence that doesn't include the reasonableness scale. It has to be part of it. This court held in Newman that the duty element of negligence turns primarily on foreseeability, and that the risk to be perceived defines the duty to be obeyed. So even if you don't offer proportionate duty, there must be a way for the jury to consider this on the scale of reasonableness.
I'm sorry, one more question.
Sure.
Does the instruction on medical malpractice negligence that requires proof of a departure from the applicable standard of care cover this landscape for a med mal case?
It does not, because it does not incorporate.
Reasonableness add to that?
Because reasonableness is the only method that this court has identified to instruct the jury on foreseeability. This entire case was about foreseeability. So in the absence of any instruction on this, we were unable to say that the doctor's conduct in conforming with the standard of care had to be reasonable, that the acts had to be considered. Every doctor testified that the most significant risk in delaying treatment was blindness. This is a known foreseeable risk.
Was it a disagreement about, if the doctor's conduct met the standard of care, then by definition, wasn't it reasonable?
Well, there was ample testimony that the doctors reached the standard of care.
Right, that was the conflict, but why doesn't this instruction allow the jury to resolve that conflict?
Because it doesn't inform the jury of the law of reasonableness. So the jury has to determine what the standard of care is based on doctor testimony, but the jury is still in charge, and it's still the province of the jury to determine whether the defendant's conduct is reasonable. It is a core tenet of negligence, as this court has held many times. Now, I don't know what instructions were given in Steffensmeyer, but ordinarily there is an instruction, a basic instruction, that reasonableness is one of the basic duties in negligence. It's wrapped into the duty analysis. So looking at BUSTA, seeing that foreseeability is covered by an instruction regarding reasonableness, this instruction should have been given in whole or in part, even if proportionate duty isn't at issue in medical malpractice. I think the proportionate duty instruction should have been given, but regardless, at least a reasonable analysis had to be conducted by this jury.
Counsel, let me ask you about the instruction. I'm intrigued by your comment that it may not have been constructed in the best way, and I had a question about that because your briefing does acknowledge that this is a case with multiple risks and talks about that there had to be a balance between the known risks of one alternative versus the known risks of the other. And the instruction speaks about danger in a singular way, a single danger, that the defendant has to consider the danger and act in accordance with the danger. And why isn't that a bit misleading to a jury to talk about a singular danger when it's a case acknowledged to have multiple ones? Shouldn't the instruction at least have been stated in the plural that there are multiple dangers and that they have to be assessed individually?
Yes, that could have been done, and it was an obligation of the trial court to craft an instruction that if that was the objection, that this was not a single risk, then the instruction should have been crafted to accommodate that, as in Panu. Moving on to
That wasn't the objection, though.
It was not the objection. Moving on to plaintiff's instruction, offered instruction number 11. This is in your handout, highlighted on pages 80 and 81 of the appendix. The trial court rejected Camen's offered 11 on the crucial theory of Camen's case, the loss of chance of recovery instruction, which reads, a doctor's negligence is a cause of damage to the plaintiff if it increases the risk of harm to the plaintiff or reduces the plaintiff's chance for obtaining a better result. This pattern instruction was approved in Osham, and this court discussed it in Steffensmeyer and held that the statute, 27-1-739, codified that instruction. The legal basis for the trial court's determination that it should not give this instruction was flawed. It was error, and it should be reviewed de novo. The trial court determined that 27-1-739 superseded the statute. or the jury instruction and the Osham case. There's no legal basis for that determination in Montana law. Also, the district court then went on to abuse its discretion by invading the province of the jury. Once the district court determined that 271739 applied, the district court then weighed the testimony of the experts without notice to the parties that this was going to be happening, decided what he thought the experts had said, and then said, this cause of action doesn't go to the jury. This wasn't so much a rejection of a jury instruction as directed verdict on the loss of chance of recovery claim. The claim that Brett had proceeded with from the opening day of the complaint.
Let me ask you another question about that. I realize you weren't trial counsel and didn't draft the instructions, but again, the proposed instruction, the language of the proposed instruction was changed in the statute, and would you acknowledge that they're different?
They're different in requirements, wording, I should say.
Right, and that's my question. We haven't had a chance to look at this statute in detail, but it says that damages may be awarded if the negligent act or omission reduces a plaintiff's chance of recovering and is a cause, the negligent act or omission is a contributing cause of no recovery or recovery of lesser extent. How does that change what the plaintiff has to prove as opposed to just saying it reduces the plaintiff's chance for obtaining a better result?
I don't think it does change what the plaintiff had to prove under 3A.
We tend to assume that if there's a change, if the legislature makes an express statement that's different from the language of a prior statute or rule of law, that it means something. So I'm a little puzzled by what this means, this change in the wording.
Well, one of the problems, as you will read in the jury instruction settlement transcript, is that nobody really understood what that meant. And there was some discussion regarding, what does recovery mean in this statute? Does it mean full recovery? And it's ludicrous to me to argue that this statute does away with loss of chance of recovery unless there was a chance of full recovery. The whole point of the statute is to allow recovery for a lesser outcome, which is exactly what happened in this case. Now, I agree with you, the wording of these statutes, this was an MPI instruction. So with no notice that this was a problem, that's the instruction that's been given.
Well, the statute, though, I mean, Rule 51 puts the burden on the party to present a proper instruction.
Yes.
And even though we do have case law that the court's obligation is to instruct the jury correctly, the statute puts you on notice how to how to prepare your instructions. So I guess what I'm struggling with is the plaintiff's obligation here vis-a-vis the trial court's obligation.
So the plaintiff's obligation is typically met by offering the MPI instruction, which is exactly what was done in this case. And while the statute may have put people on notice that there was a change, it's unclear that that changed the law, especially given this court's precedent in Steffensmeyer saying that this codified, the statute codified the existing law, didn't change it. There was no finding of that in Steffensmeyer. But in this case, this is extremely prejudicial because I think in the brief I referred to this as an off-the-cuff objection. This 271739, it wasn't raised by either party. The instructions were submitted 20 months before trial. The MPI was there the whole time. That's what we were going on. And at the settlement of instructions, they raised 271739 for the first time. Didn't preserve that in the pretrial order. Neither party did. There was every reason to assume that the parties agreed that MPI instruction was the proper instruction. You know, in the pretrial order where it says issues that need to be decided at trial, this isn't listed there. There was no advance warning that this was going to happen. So that was extremely prejudicial. Now, Could we all have done a better job drafting an instruction? Maybe. But that doesn't eliminate the harm to Brett Camen for pulling his theory of the case. Now, the main argument proffered by the doctors is that this was harmless error. They rely on Steffensmeyer. In that case, this court held that because the jury did not reach the issue of causation, the outcome would have been the same had the error not been committed. You can't reach the same conclusion in this case. The jury was instructed differently here. Unlike in Steffensmeyer, at least the record we have of Steffensmeyer, you got to look at the instructions that were given, and just as the jury needs to look at them as a whole and apply them according to the judge's instructions, we need to look at them and assume that the jury acted in accordance with the instructions given by the trial judge. So, special verdict form, what did it ask? Two simple questions. Was GEC, Dr. Stein, negligent? And, same question, was KRMC, Dr. Wheeler, negligent? The jury had been instructed, specifically in instruction 20, that, quote, to establish negligence in a medical malpractice action, plaintiff must present qualified expert medical testimony establishing the following elements. 1, the standard of care applicable to each defendant physician. 2, departure from the applicable standard of care. And 3, that the departure from the standard of care caused injury to the plaintiff. Causation was instructed as being part of what plaintiff must prove to establish, not breach. That's not the distinction. They were instructed that you had to look at causation in determining negligence. And the question on the special verdict form was, were these doctors negligent? Wasn't, did they breach the duty? Is there a departure? They asked about negligence, and they had been instructed to consider causation as part of that. They were also instructed that you should take the law in this case from these instructions alone. You are to consider all of the instructions as a whole and are to regard each with light to the others. So, unlike in Steffensmeyer, you can't reach the same conclusion that no harm, no foul, because the jury was instructed to include causation in determining what established negligence. Also, there's prejudice here and harm because of the way this occurred. This was actually, when you look at it, a directed verdict on plaintiff's claim of loss of chance of recovery. The judge decided that 27-1-739 superseded Osham and the MPI instruction we'd relied upon throughout the case. The trial court refused plaintiff's request to tailor the special verdict form to include 27-1-739. The trial court then abused its discretion by weighing the testimony of the experts. That's the province of the jury, not the trial judge, and determining that this claim was not going to the jury. When asked by plaintiff, and this is on your handouts, if you look at the last highlighted ruling, on page 656, plaintiff's counsel, Mr. Rowley, obviously wondering what's going on, that they're not going to get this instruction. And he asks, the testimony in the authoritative literature that Dr. Wheeler talked about, that we went over, talked about how patients got the timely treatment, got better, they recovered their vision. That was in evidence in this case, and Dr. Lee continued to testify that it would be better. My question is, did the court say that that's covered by something else so that this is duplicative? Or now I guess we can't pursue a win on that theory? I just want to be clear. And the judge responded, the court's ruling is as it's stated. We were not allowed to argue loss of chance to the jury. The claim was withdrawn from the jury's consideration. The court determined it after weighing the expert testimony on his own and withdrew the claim from the jury. It's prejudicial. It's the glaring example of prejudice. Finally, I want to talk about how the arguments, the closing arguments, also established the harm in this case. The instructions are, in fact, an operator's manual. It was a great argument. And GEC and KRMC were able to go through the many jury instructions, one by one, that set forth the theory of their case and say, the judge instructed you, this is how the operator's manual worked. We didn't have any instructions regarding the theory of our case. We didn't get to say there's a cause of action for loss of chance of recovery. All of our evidence had been pointed towards loss of chance of recovery, and there was no legal basis instructed by the judge to the jury for us to make that argument to the jury. There are two other issues on appeal, and they both are reversible error. They're covered in the briefs. We have Dr. Wheeler's undisclosed testimony and then the jury polling. And unless you have any questions on those after reading the briefing, I'm going to save the rest of my time for rebuttal.
Mr. Chief Justice, and may it please the court, Dale Schongert for Kalispell Medical Regional Center and its employee, Dr. Marcus Wheeler. With me today is Sean Gokachia, counsel for Glacier Eye Clinic, and its employee, Dr. August Stein. With the court's indulgence, we're going to split argument today. I'm going to cover the first two jury instruction issues and the jury polling issue to the extent the court would like to discuss that. And Mr. Gokachia will discuss the admission of Dr. Wheeler's testimony. I'll go for 20, 25 minutes of that time. This appeal asks you to overturn a jury's verdict after a complex 8-day medical negligence trial because Mr. Camen asserts that the district court abused its discretion in issuing 4 rulings. Camen has a heavy burden. The district court was correct, but at a bare minimum, it did not abuse its discretion. And even if the district court erred, Camen has not met his burden to show that it would have resulted in a different outcome at trial. I'd like to start with the proportionate duty instruction. The district court rejected it because it would have confused the jury about the standard of care. That's a discretionary decision that the district court has to make after hearing the expert testimony and the other testimony in the case.
Counsel, can you explain to me how you believe that would have confused the jury here on the standard of care? I don't really follow that argument.
It would have confused the jury because the proportionate duty instruction is given in cases where there's one actor, one known unusual risk, and an identifiable moment in time where there's a heightened risk and a duty to avoid it. Schaff, Dale, the state of Strever. Each one of those cases had that fact pattern. Schaff, boat driver going down the Missouri, had a duty to avoid what he knew were underwater rocks he'd traveled 100 times. And there's heightened risk of hitting those rocks and damage.
Isn't that why doctors go to med school, to appreciate the risks of any action that they take?
Absolutely, and that's our point. When a doctor's evaluating a patient comes in, unless it's just a wellness checkup, they're coming in with something seriously wrong, and the doctors are evaluating competing risks, not just one, and that is certainly the case here. Now, we're not saying that this instruction could never be given in a medical negligence case. There perhaps are cases where it could be, and I'll discuss one that my friend discussed in the Panu case. But here, consider what the doctors are weighing. First of all, the IIH, intracranial or idiopathic intracranial hypertension, extremely rare circumstance by itself. 97% of all cases are overweight females of childbearing age. The rest are mostly men, older men. To have a 16-year-old come in and present with that condition, exceedingly rare. The second factor, Dr. Wheeler prescribed Diamox. Diamox was working. It was relieving the intracranial pressure. It was having some impact on his eyesight. Second factor that the doctors were considering. Third, shunt surgery. It carries significant risks. It is brain surgery, so it carries risks of stroke, death, brain infection.
But isn't that, I mean, you're talking about a risk-benefit analysis, which was specifically argued by Dr. Wheeler's counsel at trial. I mean, isn't that just the flip side of the risk-benefit analysis? If the risk of not doing it is greater, it seems to me like you're carving out one part of the equation. You've got the risk of not doing it, you've got the risk of doing it, you've got what can happen with either choice. And he wanted to argue, and did argue, in closing, this was a classic risk-benefit analysis. And, I mean, it just seems to me that, like, that's just the flip side of the same coin.
Absolutely, but Your Honor, Justice Shea, he was able to argue that. His experts argued that. He argued it in closing. He just didn't get a jury instruction that established that predominant risk, that there was one risk that predominated the others.
But the jury instruction was a correct statement of the law. It was just a verbatim recitation of what we endorsed from the restatement.
Absolutely, and that's why, but the experts established a standard of care, and the experts are evaluating those competing risks and discussing what the relative risks at one moment at a time. And I can't imagine how confused the jury would have been if it got an instruction that said, there's one risk here, and the doctors had a duty to...
So this case, you're saying is distinguishable from the others because there's only one risk in these other cases?
Correct.
So when you're in a river and you're in a raft, rocks are the only risk?
That was the...
Speed doesn't have anything to do with it, high water doesn't have anything to do with it, other boaters doesn't have anything to do with it. I mean, right? I mean, aren't there lots of risks in those other cases? It's just that particular, it happened, they hit rocks.
The predominant risk there that the court identified in Schaff was the rocks. I mean, that was the risk to be avoided, and the court said the boat driver knew those rocks were there.
So the predominant risk here wasn't loss of eyesight?
No.
Wasn't
no.
that what was identified?
No, because at the time, shunt surgery, look, the doctors acknowledged that, look, we don't know what the cause is here. We're trying to figure that out. We've got him on Diamox. That's having some effect. We've got to rule out other causes, like blood clot in the brain or leukemia, especially because some of his symptoms were consistent with leukemia. He had retinal hemorrhaging in the eye, and that's a symptom consistent with leukemia, not consistent with IIH. That's uncontested by all the experts in this case. So that's what the doctors were evaluating there. And shunt surgery would not ever be an appropriate remedy for leukemia. So until they had ruled out those other causes, until it became clear that the Diamox wasn't working, the heightened risk, that's a hard thing to evaluate, and that's why these doctors were evaluating competing risks. It's unlike those other cases that this court has decided, whether it's Schaff.
Counsel, that's fine in those other cases, but nothing in those other cases suggests that a proportionate duty theory is limited to those scenarios. So this whole colloquy that's been taking place here kind of illustrates the point, I think, that the plaintiffs are trying to make here, that this was a theory that was supported on the evidence in the case, and why couldn't they get an instruction that would support that theory, that fact theory in the case?
Well, first of all, it wasn't a theory. It was a late-coming theory in the case, first of all.
It what?
It was a late-coming theory. That theory was not in the final pretrial statement. Nowhere. It increased risk, increased harm,
The
proportionate.
trial evidence supported this argument. Do you at least concede that?
I think the trial evidence supported.
Even though you don't agree with the argument?
The plaintiff made the argument, 100%. I agree with that. The plaintiff made that argument. Their experts tried to establish that heightened care. But the jury also heard about all of the other risks that were involved.
And I agree with you about that, but the point here is that it's long established that parties are entitled to a legal instruction that supports their theory of the case if it's supported by the trial evidence.
They're entitled to an instruction that is adaptable to the theories of their case. They're not entitled to
What
an instruction.
instruction here covered the subject matter that this proposed instruction covered?
21 and 22. So the instructions that covered the
How so?
the standard of care for medical, that the standard of care is established by medical testimony. It requires the care and skill of like board-certified doctors in similar circumstances. And that's exactly what the
That's
plaintiffs.
not a proportionate, doesn't support a proportionate duty theory. Yes, you can make the argument within a larger framework of that, but there's no legal instruction that provides the jury guidance that that's a cognizable theory of recovery.
But, Your Honor, you don't have to have an instruction that spells out. In fact, it would be confusing to the jury and risk invading the very standard for medical negligence cases that experts establish the standard of care. And the judge played this both ways. So the defendant's Alfred instruction number 13, and docket number 62, it was a best judgment rule for the standard of care. The judge said, no, I'm refusing that. You're not entitled to an instruction on every nuance of your case. And that, the instructions were adaptable to both parties' theories.
Those theories in the cases that are out there are largely applicable in cases where this court has viewed them, or the trial court in the first instance viewed them as having been perhaps an undue or too close to being an undue comment on the evidence. And I don't see anything here in the text of this instruction that would fit that criticism.
The criticism, and this is what the district court identified, was that it would confuse the jury because it would put them in the place of, it would confuse the standard of care. It would risk putting them in the place of establishing the standard of care. And that is because there are multiple risks. And that was evident from the instruction number 9 that they were offering.
That's the case.
It's not the case. It's the case.
Those are the facts of the case.
If it had been the case, they would have put it in their pretrial statement. They didn't.
Are you suggesting to me that trial evidence in these cases only comes in accordance with what's in the pretrial order?
I think the pretrial order establishes.
Why don't we settle the instructions in advance of the trial evidence?
Because then they have to be consistent, but that guides every party in the case. As my friend said when she was up here, that was the framework that establishes what puts everybody on fair notice of what's going to be tried. Now,
what was
we didn't
unfair
object
about this instruction being in the instruction set in the context of all of the other instructions?
Because it's confusing. It puts one risk predominant over others, and that was not consistent with the evidence.
I still don't understand that on this text, and I know you got interrupted by another question, so could you explain that to me? Because I don't see that point.
Explain, I'm sorry.
That this instruction focuses on a single risk.
The instruction itself, by its language, instructs.
It seems to me, counsel, that the instruction, it was clear until we had this argument, but it's a heightened risk. It just, I don't see how it's limited to one situation. It's saying that the standard of care has to consider the degree of risk and harm.
The danger involved in his acts and is proportionate to that danger. But it's assuming one danger, and that's the problem. We're not assuming one danger. There are multiple dangers.
Well, I don't see how it is limited to one danger.
Well, but how does a jury determine that? How does a jury determine that when there's no moment in time? Because there was disagreement on when you can diagnose fulminant IIH, when the risk of blindness occurs. So how is a jury supposed to evaluate when that risk predominates over the other risks, the serious risks of shunt surgery, or the other evaluations that the doctors were making that, for example, the Diamox was working, they had to rule out other causes. That's the problem. Now, like I said, they were able to argue this in their...
That's your factual theory of the case, is it not?
It is a factual theory.
Okay,
Yes,
so
certainly.
that's fine, and that's great jury argument, but how does this, why should that then, that factual theory of your case preclude them from being able to make an argument supported by an instruction that fits the trial evidence that furthers their theory.
We didn't get an instruction saying, oh, there are multiple risks and doctors can.
Did you ask for one?
No, because it would have been improper. I mean, number 20.
That's an irrelevant point here as we sit here focusing on what the issue is.
It's not an irrelevant point, Your Honor. And keep in mind, this is an abuse of discretion standard. The district court, even if you disagree, did the district court abuse its discretion? And I think it's clear here that he didn't. He heard the facts, he heard the evidence. That this would have confused the jury, this would have risked putting them in the place of evaluating the standard of care, because there was a variety of testimony in this case on the risks, on when they became apparent, and what to do about them.
Mr. Schoengert, I don't want you to run out of time before we reach the other issues, so I'm going to interrupt here and just ask you about the next instruction, because unlike what you're saying about the proportionate duty instruction, this loss of chance was raised early and often by the plaintiff. It was the central theory of the case. It was instructed by the district court in instruction 1 that the claim was that these doctors delayed treatment, and that delay is what caused the injury. So despite the nuances, I guess, of the different wording in the statute, it's the trial court's obligation to instruct on the theory of the case, and I want you to respond to Ms. Sheehy's argument about that.
Sure. First of all, the facts of the case didn't support the instruction. I mean, they did, because there's 3A and 3B in that instruction, and it has a different formula if it's more likely than recovery is more likely than not, or not more likely than not. First of all, it talks in terms of recovery. That's the first problem. And there was no evidence that Brett Camen would recover.
It says if it's a contributing cause of no recovery or a recovery that is of lesser extent or quality. So the argument being that he could have retained some vision had the shunt been inserted earlier, wouldn't that be a recovery of lesser quality than no vision at all?
It could be, but and I think that's a fine way to read the statute. I'm not sure it's how the legislature intended it, but I could see the reading. But you still have to hit whether it's more likely than not or not more likely than not. And that was.
Isn't that the jury's province to make that determination, whether it was more likely or not?
I think when the evidence wasn't presented in that way, it would be confusing to the jury to determine whether it was, because they said it was, at one point it was 50% toin costs, with a 48 to 68% failure rate of shunt surgery in the first place. And then another part, they said it was 80%. So I think the district court said.
So you're agreeing that the district court essentially directed the verdict on that theory?
No, I don't know. I think they were still able to argue that there was loss of chance. They just didn't get the instruction because they never offered an instruction that complied with the statute and never explained why that was an issue or how their evidence fit with the statute.
But isn't there some onus on the district court when you talk about properly instructing the jury when this wasn't a specially crafted instruction? It was a pattern instruction that we had specifically endorsed in Steffensmeyer, and that we had also said in terms of the district court's reasoning that 27-1-739 codified that rule. And I mean, it just seems to me like it's one thing if somebody crafts an instruction out of whole cloth and the district court refuses it, and then you can say, okay, then the onus is somewhat on the person to propose a modified instruction. But when he just shot down a pattern instruction, it seems to me like there's some responsibility on the district court to figure something out so that the jury is correctly instructed as a whole.
It would have been error to, I think, to give the instruction that was approved in Ashheim, because it's not. It did codify that rule, but it codified it with a different language, and that was what controlled. And if there isn't evidence that supports that instruction, which is what the district court found, and he's entitled to abuse of discretion on that.
Yeah, but we're also, you had the Steffensmeyer issue where we said that the statute just codified, whether that's correct or not, and to a certain extent, maybe that's on us. But it seems to me like it needs to be more than in terms of the district court's responsibility to just say no.
Well, the court in Steffensmeyer didn't analyze it in depth, and the reason they didn't analyze it in depth is why I think this court doesn't have to either, because you don't even have to get there. Here, the jury found that these doctors were not negligent. That proposed instruction number 10 is clearly a causation instruction. In fact, it says, a doctor's negligence is a cause of damage to the plaintiff if it increases the risk of harm to the plaintiff or reduces the plaintiff's chance for obtaining a better result. That's
That
exactly.
goes to the harmless error argument, not to whether it was error.
Yeah.
It's just whether it was harmless or not.
It does, but I mean, my point is that there wasn't a lot of analysis in Steffensmeyer. So it said, it codified it, but it also recognized it. Since our Ashheim decision, okay, the legislature enacted this statute. The statute clearly lays out a different format. Same topic, but different format than what was approved in Ashheim. And so I think the district court had to follow that statute. I mean, it displaced the common law. The court had to follow that statute. And he determined after listening to the evidence that it didn't meet, that the plaintiff didn't meet the qualifications of that statute, and it wasn't triggered. I think he's entitled to abuse of discretion on that standard on that question. So, but again, that does go to the harmless error question, because here the jury verdict form, or the special verdict form, was almost identical to Steffensmeyer. It laid out, first of all, is Dr. Stein negligent? Is Dr. Wheeler negligent? No. If you answer no, you don't even go to the next question, which was causation. And that's how a jury would typically think about this issue. And my friend argues that there was confusion on causation and negligence. But first of all, she focuses on instruction number 20. That was agreed to by both parties, that instruction number 20. Second, number 17 lays out the elements of negligence. The plaintiff has the burden of proving that and this is Plaintiff's Appendix 161, the defendant was negligent first, that the plaintiff was injured, that the defendant's negligence was a cause of the injury to the plaintiff. Number 21 is explicit when it lays out the duties of a board-certified doctor. At the final sentence, it says, violation of this duty is negligence. 23 and 24 deal with proximate cause in general and causation in general. Those duties were separated in the jury's mind. That's how counsel argued it throughout the trial and in closing. That if you don't find the doctor's negligent, you don't even go to causation. So this instruction, is interesting. A question this is. I don't think the district court abused its discretion. The facts did not support this instruction. The plaintiff never gave an instruction that fit 27-1-739.
How do you think the statute differs? That was my question to Ms. Sheehy.
The statute differs, I think. The language differs because it talks of chance of recovery, and perhaps there's a little bit of ambiguity there. But I think primarily the statute, and this is what in the colloquy that counsel had at trial, it was really focused on 3A and 3B. Is there a more likely chance of recovery or a not more likely chance of recovery? And so I think that framework is completely different than the instruction that...
They should have been focusing on D.
On D?
On D, a recovery that is of lesser extent or quality where it takes longer to occur. I mean, it's right there, and...
Okay, sure, but they still have to get to 3, I mean, you can't stop there. So then you get to 3A and 3B. It's like, okay, is the chance of recovery more likely than not or not more likely than not?
Right.
And the judge would have to give a complete instruction on that issue, and they had not had proved the facts to support that. I also, just because I wanted to mention it, I hate to go back to proportionate duty, but just one quick point, because it's PANU, the district court's case. There's only one case, I think, that, at least at the appellate level, that either party has cited where the proportionate duty instruction was approved in a medical negligence case. That's PANU, the District of Columbia Appellate Court of Appeals. That case shows the framework where it could be appropriate in a medical negligence case. One doctor, one known risk. He was performing routine lumbar surgery, relatively routine lumbar surgery, but there was one big risk, and that was hitting the dura, the membrane that covers the spinal cord. That was his duty, and if he hit it, it was serious consequences. was simple to avoid, and the court said, under those facts, proportionate duty is appropriate. And it still was a 2-to-1 decision. But I can see it there, because there's one factor, one known unusual risk to avoid, and a clearly identified moment in time where that risk needed to be avoided.
Why can't we, in this case, there's multiple doctors, there's multiple risks. Why couldn't we, like Panu, say, well, if this instruction had been revised a little bit to reflect that, it would have been fine.
I'm not sure how you would revise this instruction to reflect that, and that's the problem.
Make it plural.
Well, yeah, but
It's just an S at the end.
I did not think of that. The problem is that
Does that fit everyone's theory? They get to argue there's multiple risks.
I think the instructions as they were given fit everybody's theory, because the experts themselves are establishing the standard of care and how you weigh those risks, what the risks are, when they come into play, and for what doctors. I don't know how you construct an instruction that would detail all those things that wouldn't be horribly confusing to the jury. Unless the court has any questions about the jury poll, I'll let Mr. Gokachia argue the admission of Dr. Wheeler's testimony.
Thank you. May it please the court. Sean Gokachia on behalf of ophthalmologist Dr. Gus Stein and his clinic, Glacier Eye Clinic. I will jump ahead a little bit in my comments. The first thing I would like to start with is just to remind the court what you all know very well, which is the issue of the admission of testimony at trial gets reviewed on an abuse of discretion. It's not whether you would have done something different had you been faced with it. It's a question of whether or not the district court acted arbitrarily or without conscientious judgment or exceeded the bounds of reason. The one issue in this case that's been raised about testimony that really has been argued to any length is this opinion testimony allegedly given by Dr. Wheeler at trial. And the argument is that testimony was opinion testimony on the standard of care that applied to Dr. Stein, an ophthalmologist. Time course is important for this argument to understand the context of what the judge knew at the trial court level. Brett Camen started experiencing symptoms associated with IIH in November of 2017. In the middle of December, he started experiencing vision symptoms related to IIH. And remember, this is a disease that once those things start, it acts quickly, and plaintiff's experts said within days or a week, maybe you can lose your vision. So middle of December, he's diagnosed and evaluated by his primary care provider and his optometrist, who were not parties to this case. Dr. Wheeler is then involved in a telephone consult a few days later. Dr. Stein still doesn't even know who Brett Camen is because he was never consulted until much later. So Dr. Stein is involved in this case because the optometrist, Dr. Sorensen, writes him a letter on December 28th. He puts it in the mail. It goes to Missoula and back up to Kalispell and arrives at Glacier Eye Clinic on January 2nd. They read it the morning of the 3rd. They get Brett Camen in the office to see Dr. Stein on January 5th. They add him to his clinic. Brett had seen Dr. Wheeler on the 3rd. Throughout the entire course of the trial, the plaintiffs had criticized Dr. Wheeler, who had been disclosed as an expert, to testify about his own activities and whether they were reasonable. Plaintiffs concede that, and they actually encouraged him at trial to testify as an expert. The plaintiffs' counsel did. They criticized Dr. Wheeler for not making referrals sooner and not following up sooner after the 3rd. So one of the very last questions Dr. Wheeler's counsel asked him during his examination was this question that's at issue at page 72 and 73 of the trial, or of the plaintiff's appendix. It's trial transcript 1331. It's a question about timing. The plaintiffs argue, and they paint with a very broad brush because the details actually don't help them. The broad brush does. they argue in their brief that this was testimony, providing testimony that Dr. Stein's evaluation and treatment of Mr. Camen on January 5th was reasonable. That's their argument. If you read the testimony very carefully, the testimony says, "We know from testimony in this case that there was follow-up after your visit, in fact, 2 days afterwards by Dr. Stein. Was that, in your view, reasonable and appropriate for Dr. Stein to then begin for the first time his evaluation and assessment of the patient?" There was an objection, overruled, and the answer was yes. The appellant completely ignores the words, "then begin for the first time." You can't ignore the time element of that question to argue it's prejudicial error. It's not. When you consider the timing, it was appropriate for Dr. Wheeler to say it was reasonable for an ophthalmologist to see this patient 2 days later. Plaintiffs never argued it was unreasonable for Dr. Stein to get involved on January 5th. That was not a claim they made. It was not a claim that they argued. And the reason is Dr. Stein or Glacier Eye Clinic had no control over when Brett Camen was referred to him. The last thing I want to bring up is there are several things where the plaintiffs try to argue prejudice from the admissions, and it flows over in the jury's directions too. They say the court should have fixed these things. The court had an obligation to fix these things. And the question becomes where you draw the line of plaintiff is supposed to offer instructions that they want or are supposed to object to testimony instead of relying on the court to fix things for them. A couple of examples of this. Plaintiffs cite at length testimony at 1332 of the record saying it's prejudicial. They never objected to that last question to Dr. Wheeler. There's no objection. Another example is they talk about at length how their counsel was only allowed one question after Dr. Wheeler's testimony. He didn't ask for more. And the last thing they argue about is how the court handled the question of the jury that was sent out during deliberations. They say that was grievous prejudice caused by how the court answered that question. But they never objected to it. In fact, they wholly endorsed the response that went back. So the record has to be carefully reviewed to confirm it proves the prejudice that they're arguing.
Thank you, Mr.
Thank you.
Ms. Sheehy.
Thank you. I'm going to start where they finished. I'm going to start with the Wheeler testimony. That's our brief argument. Section 26.2.601 provide a really clear rule that nobody really disputes. A doctor qualified in one specialty cannot drift into offering expert testimony on a different specialty. That's error. Dr. Wheeler testified that he was not an ophthalmologist in his deposition and that he was unable to testify as to the reasonableness of the ophthalmologist's conduct. At trial, the testimony changed. And he testified that Dr. Stein acted reasonably. This was error to allow that testimony. We did object to it. I refer the court to...
So let me just ask you to clarify whether when the objection was made, was it based on this timing issue that Mr. Gokachia raised? I'm a little confused by his argument in that regard.
You know,
when was the objection?
The objection was made simultaneously with the testimony going in. And there was a lot of colloquy among the judge and the parties. I think there was a sidebar. And they talked about whether or not this exceeded the disclosure and exceeded the expert testimony. And then they went back in and they decided that the only rebuttal that could be made by plaintiff was to read in the prior testimony without cross-examining the witness. So I would like to refer the court to the decision in Christofferson versus City of Great Falls at 2003 MT 189. It's kind of a similar situation. In a deposition, an expert was asked if he was aware of any studies that pertained to the survival rate for someone who suffered pre-hospital respiratory arrest. He answered no, and at trial he changed his testimony. In the concurrence in that case, Justice Rice stated, "I find that the city's tactics were unfair, that plaintiff was ambushed by the witness's inconsistent testimony, and it should not have been admitted." However, the court and Justice Rice noted that there was no prejudice because there was such a strong cross-examination, described by Justice Rice as a very skilled cross-examination that cured any prejudice. We weren't given that opportunity in this case, so we believe that it is error to allow Dr. Wheeler to testify to the qualifications or the actions of Dr. Stein. Unless there are any more questions on that, I'm going to go back to the instructions. Plaintiff's 9.
First, before you go there, do you agree that the standard of review with regard to the instructions is abuse of discretion?
I don't, not entirely. Several of these decisions that were made by the trial court were legal decisions, and those are reviewed de novo. And I think both parties cite to that case in their statement of the standard of review. So no, there are legal decisions here which were incorrect, should be reviewed de novo, and constitute reversible error. Before I get into these instructions, I want to point out what they aren't arguing. The doctors have failed completely to refute that Brett Camen, the jury was not instructed on Brett Camen's theory of the case. Under Peterson, Chambers, Ricks, that is reversible error. They claim that we haven't shown prejudice. That's the prejudice. This court recognizes that in Chambers, that while failure to instruct on the theory of the case is prejudicial, beyond that, it is reversible error. And they have completely failed to establish that this jury received any instruction regarding Brett's theory of the case. That's what makes this trial unfair. That's what requires reversal, so that Brett Camen gets at least one chance to present his case to a fully informed jury based on his theory of the case as instructed by the court. With respect to plaintiff's instruction number 9, the doctors argue that this is not a single risk case and only applies to single risk. Shuff is not a single risk case. In Shuff, the many risks were considered by the court. There was a narrow channel, there was a hidden sandbar, there was an underwater rock, there was the speed of the boat, the speed of the current, the depth of the boat. All of those things were risks that were tested to by experienced boaters in that case, and those were the risks that were being weighed, and still the instruction was proper. The doctors argue the facts here. They want to tell you all the expert testimony and how that's going to come out. That's exactly the error that was made by the trial court. It is not the trial court's job to decide how the facts should come out. That's the jury's job. It's the jury's job to decide all of these issues regarding the weighing of the differing expert testimony. So the facts, you can dive into them, but it's inappropriate because that's the jury's job. That's the point of this appeal. The jury did not have the opportunity to weigh the facts of this case under applicable law. My friend, we've all agreed to say my friend because we can't pronounce each other's last names. My friend argues, how does the jury evaluate risk? The answer to that question is on a scale of reasonableness. That's the answer. It's been the answer in negligence since the beginning. You evaluate risk on a scale of reasonableness. And in denying the proportionate duty instruction, the jury was never informed of that. They didn't know what to do with the expert testimony because they were never told. You evaluate risk on a scale of reasonableness. My friend also argues that instructing the jury as to the applicable law isn't necessary because all the experts got to testify. And all these facts were before the jury. That completely ignores the prejudice of not having the judge tell you, give you an operator's manual as to how to reach a verdict in favor of Brett Camen. That operator's manual needed to include Brett's theory of the case. And I will tell you that they ran a truck through that in closing arguments. They established the operator's manual, informed the jury that they had to stay within that operator's manual. You can't go outside these instructions. And we didn't have any instructions in the operating manual to argue two of the most crucial parts of our case: how to evaluate risk and loss of chance of recovery. This jury didn't even know that Montana law in 27-1-739 specifically authorizes a cause of action for loss of chance of recovery. None of our evidence made any sense because the jury didn't have any law to hang the evidence on. So the prejudice that resulted from the rejection of Plaintiff's 9 is incredible. It's just, Brett could not get a fair trial without being able to discuss foreseeability under the law this court has always acknowledged. In addition to that, I think they've now conceded that this is an instruction that could be offered in a medical malpractice case, even the proportionate duty, not limited to reasonableness. I agree. There is no problem instructing a jury in a medical malpractice case as to how to evaluate the evidence before it. And I recommend the instruction that the court in Panu came up with. It's a good instruction. As to Plaintiff's 11, talked about how the trial court weighed the evidence. There's no question that the trial court decided to throw this claim out. They said the trial court decided 27-1-739 applies, and then look at the transcript, went through a colloquy about what he remembered from the evidence, and said, this isn't going to the jury with this instruction. And when asked by plaintiff's counsel, you mean we don't get to go on this theory? He said, my instruction is as stated. We didn't get to go to the jury on loss of chance of recovery. And that claim is recognized under Montana law. There's no question about it. We talked about the onus being on the plaintiff in providing jury instructions. Plaintiff met its burden here. It provided an instruction that's an MPI instruction that certainly appeared to be approved by this court for use in medical malpractice cases in Steffensmeyer. We met that duty. And then without any warning, the doctors stated, oh no, that instruction doesn't apply. They have some obligation here too. They didn't raise the issue in the pretrial order. They did not move for a directed verdict. We had no notice that this was going to happen at the settling of instructions. You read those transcript pages and you'll see plaintiff's counsel saying, it's really late. I'm trying to think my way through this. But this was an ambush. And I think that the doctors were kind of the dog that caught the car. I don't think anybody thought that this claim was going to get completely thrown out during the settling of instructions. And the plaintiff did ask, can we have overnight? There's some reference to we could craft that. We haven't settled the special verdict form yet. We could craft something. But defendants also have some onus here to notify that there's an issue with an instruction that's been sitting there for 20 months, to move for something to give us some notice that on the 8th day of trial, we're going to ask that your claim be dismissed on loss of chance of recovery. It's highly prejudicial. So I don't think that they've met their burden of establishing that we were not prejudiced by the failure to instruct the jury on two crucial parts of our claim: the foreseeability and the loss of chance of recovery. On behalf of Brett Camen, we respectfully request that this court reverse the district court and remand for a new trial, a fair trial, where the jury is fully informed of Brett's theory of the case. The irony of this situation is lost on me. This is Brett's last chance of recovery right now, today. Thank you for your time.
Thank you to all counsel. This includes the argument on this matter. We will take this case under advisement and issue an opinion in due course.